Ms. Abby Bhattacharya is the Technology Transfer Manager for the Office of Technology Transfer at the Defense Health Agency. She is responsible for developing and implementing technology transfer and intellectual property policy, guidance, and oversight for the DHA. It is a pleasure for me to introduce you to Ms. Abby Bhattacharya.
Hello, everyone. This is Abby Bhattacharya. I'm the Senior Technology Transfer Manager at the Defense Health Agency, Office of Technology Transfer and Intellectual Property. That's a mouthful. We go by DHA OTTIP. So I'm going to go through and share some slides with you on several topics, starting with what the DHA OTTIP's roles and authorities are, what our end state is going to be. And then I'm going to move to what is technology transfer and what DoD policies actually govern it, do a little bit of a history for you on technology transfer, similarly with patents, copyrights, and data rights. And after that, we'll talk a little bit about technology transfer agreements. And lastly, I have a little fun hypothetical for everyone. If you'd like to participate in that, I'll have instructions towards the end on how to do so. So moving on, the DHA-OTTIP was actually established in June of 2019, so it's not been around for very long. And what its intent is to actually to serve as the policy guidance and oversight office for technology transfer and intellectual property, IP, at the DHA, and that will also include all of the transitioning military treatment facilities or hospitals, as they're known in the outside world, and for any other DHA entity or organization that is interested in or already participating in technology transfer and IP. So our office really is a small office at present, and we will grow with time. But it's headed by Mr. Robert Beloit, and he's the director of the DHA OTTIP, and myself, and I am the lead, and I do the day-to-day operations for this office. So the DHA OTTIP is really discussed in DHA-PI 3201.05. That's, of course, based on some DoD procedural instructions as well as directives. And I'll talk a little bit more about that moving on. So the authority for technology transfer to the DHA comes from these directives, the DoD directives. And currently the DHA-PI is under some revision. And we are going to be looking to revise these to establish best practices and additional rights that weren't in the original. And predominantly what we're doing is also to make clear the establishment of the Office of Technology Transfer and Intellectual Property. And so additionally, the idea is going to be that our interest is to enhance portfolio growth and look for what is best for the DHA, for the laboratories under DHA, for our researchers primarily, and then also for prospective licensees. So what are some of the authorities that the DHA OTTIP is going to have? So it's going to have the authority to bind the DHA on all matters pertaining to technology transfer and intellectual property. These are business matters and resource-based matters, so we will have that authority. Certainly we'll have authority to provide designation for laboratories. This is going to be a very important aspect of our functions to allow the laboratories that are coming into DHA to continue to practice technology transfer. Certainly, we are going to also have signatory authority on DHA patent prosecution matters and also on technology transfer agreements. And overall, we're going to also be managing the technology transfer and intellectual property data system. And that's going to be both overseeing as well as developing data. For example, for the annual DoD data call on technology transfer and IP. So while we will have all of these authorities, our intent is to oversee and provide guidance and not necessarily to be involved in the day-to-day running of the offices. And so while these all might seem as if they are meant to be, that they are more day-to-day involvement, we want to have these provisions available to us, but we're not necessarily planning on utilizing them on a day-to-day basis. So this slide is actually providing you an overview of the DHA OTTIP program. And you'll see that these are 4 circles that are interconnected with one another. And that is how we see this program working. And the interconnection isn't just on the DHA level, but on the overall DHA T2 program that certainly includes the laboratories and all of the other organizations under us. So what we would be involved in, of course, is the T2 policy drafting, guidance, and implementation, which certainly is connected to the data management and reporting aspect, which is connected to the laboratory oversight, as well as the T2 education and training program and development and implementation. So we do see this as a holistic approach to technology transfer, intellectual property, from headquarters to the field offices, as we also refer to the laboratories as. So some of the things about the implementation plan that I'd like to talk a little bit about is what's going to happen. As you are aware, we have a first wave of laboratories or military treatment facilities, rather, that are going to be coming under DHA very, very quickly. We are looking at the first week of April 2021. So within 30 days of transition of the MTFs, what we will be doing is providing provisional laboratory designation status under the DHA for those laboratories that are already practicing technology transfer. Now, the Army is set up a little bit differently than the Navy and the Air Force, but our intent is to have a seamless transition without any gaps, and we are in the process of making that aspect happen. So on the 1st of October 2021, which is the new fiscal year, we are going to make sure that all support agreements are in place so that there is continuity of service provided to all of the military treatment facilities by the Army, Navy, and the Air Force as they previously have been. And we will do that via support agreements. And within the 120-day mark of complete transition to the DHA, what we want to make sure is that we are fully functioning and providing each of the laboratories the service and assistance that they need. And what we will also begin to do is assess the provisional laboratory designation to ensure that each of the laboratories that are practicing T2 are doing so in a manner that allows them to receive full laboratory designation under DHA. And so that will be an evaluation process that our office will be conducting and making a determination on. And we will continue in that process to also provide oversight, guidance, and input. So the DHA OTT IP Insight will look something like this. Now, this is not set in stone. This is our thought process of how we see things going in. And you will notice several things. You'll notice that the support agreements definitely are going to be in place for the Air Force and the Navy. With respect to the Army, because of the NDAA, which envisions the MRDC's offices coming under the DHA, we are still unsure of what that's going to look like. So that's why you'll see on this slide a dotted box to the right next to the military treatment facilities that are transitioning over or have already transitioned over from the Army. So we don't really have a full picture of what that's going to look like. But I wanted to again reiterate that we will have support agreements in place with all three of the technology transfer and IP offices for all three services, so that we can continue to provide service to all of the military treatment facilities that are transitioning over to the DHA. So let's talk a little bit about technology transfer. So the technology transfer program in the federal government was really codified in 15 USC 3710. The idea was that it would promote federal investment in research and development dollars, and not let technologies and innovations that were federally created languish within the federal government, because that had been the problem. And so in 1980, the Stevenson-Wilder Technology Innovation Act and the Bayh-Dole Act saw to it to promote both technology transfer agreements, or the transfer of technology between the federal government and the outside world of third parties, as well as allowing for institutions of higher learning, or academic institutions, the ability to be able to own and own title to innovations and patents developed using research, federally researched monies. So that was the beginning of that process. The DoD, as did just all of the other federal departments, then developed their own policies to transfer that codified statute into policies for the departments. For the DoD, that was two. The DoDD 5535.03, which talks about domestic T2 activities being an integral part of the DoD's national security mission, and also to improve the economic, environmental, and social well-being of US citizens. And it also established that this was a high priority for DoD acquisition programs. Similarly, in DoD I 5535.08, they talk again about the integral element of the technology transfer being an integral element of the DoD's national security mission, and the high priority role it would play in acquisition programs. So moving on, so when we talk about technology transfer, there are really four, possibly five aspects to it. So technology transfer has to do with technology transfer agreements, but it also has to deal with intellectual property. And that means patents, copyrights, trademarks, and trade secrets. Now, in the federal world, we don't really deal with trade secrets in that manner. And we'll talk a little bit about what might be something that would be considered a trade secret in the outside world, and how we deal with it in the federal government. But to go back and talk a little bit about patents and copyrights, because those are the two areas that we really do focus in on with respect to researchers in our laboratories. And so we'll start with patents and a little bit of history. So patents actually have been around for quite some time globally. The first patent is considered to have been granted in the 1450s in Venice for glass making. And the first practices of patents was actually codified into the Venetian Statute of Industrial Brevets in 1474. And so the US Constitutions actually took what was in that Venetian statute, and it derives it actually provided language in the Constitution that was derived from this Venetian statute. And what that says is it's to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Writings, of course, referring to copyrights, and discoveries to patents. The first patent in England was granted to John of Utinam in 1449, and it was for glass blowing. And the first patent in the United States was granted by George Washington in 1790 to Samuel Hopkins for potash, which is actually a fertilizer, and it was for a device and manufacture of potash. So what is a patent actually? So it's actually a property right, similar in some ways to having home ownership. And it is granted by the US government via the Patent and Trademark Office to an inventor to exclude others from making, using, selling, or offering for sale that invention. And it's in the United States only. And of course, it's territories, but it is United States. And it's for a limited period of time. So that limited period of time depends on the type of patent it is. For utility patents, it's 20 years from the date of filing. For design patents, it's 14 years from the date of issuance. There's, of course, also plant patents, which follow that of utility patents, the time frame for utility patents. So federal government employees, typically inventors, federal government employees or inventors typically have a duty to assign or transfer their ownership rights. So they must then, in a document, assign their rights in the patent or patentable invention to the federal government. And in return for that, and we'll talk a little bit more about this, typically inventors or government employees receive a royalty to themselves and also to the laboratory they're working for. So how does the patent process work? So typically a researcher will file an invention disclosure, and that invention disclosure is filed with the Technology Transfer or Intellectual Property Office, depending on the service. And then that it's processed by that office to make and determine whether or not there is patentable subject matter and how that particular office is going to proceed. It is a collaborative process with the researcher involved, and there's a lot of back and forth, and that's true for all of the services. And so the DHA at present, because it's developing these support agreements, each of the military services will continue to provide IP and technology transfer services to the MTF and to the MTF researchers post transition to the DHA. And we are doing so to ensure that there is continuity of service and there is no gap of service as we move forward. So if you have questions pertaining to innovations, patents, patent applications, I do encourage you to reach out to your individual MTF technology transfer office or IP office or legal counsel for assistance. And you can always contact me if you have any questions or comments about my presentation or any questions you might have in this area. Let's talk a little bit about copyrights. So copyrights actually are interesting because with respect to the federal government may not secure copyright protection under 17 USC 105. But what it can do is receive and hold on to copyrights by assignment, so by a transfer of ownership. And so a contractor who owns a copyright actually has the capability of transferring that ownership to the federal government. Alternatively, the government can acquire a license to a copyright, and that usually is in the form of a limited purpose right, which is something that you might see referred to in the DFARS. And the extent of which the copyright protects the work depends on how that work is created, and that's a really complex area. And so these aren't easy decisions for us to determine. And so it's usually done by the legal office in collaboration with the Tech Transfer Office and in determining whether or not the government may acquire a license or whether or not there's actually a transfer of ownership that needs to take place. And so I invite you to also look at this document that I've presented. It's the permissions for government prepared and non-federal authored works. And this is in something that is published by www.sendi.gov. They're actually a group of the group of people that come together from different departments of the federal government. And it's a voluntary organization. They put together a very good product for everyone to have access to. So a little bit, I'm just going to talk a little bit about some fun facts about copyrights before I move on to some of the more complex things about copyrights. So the first federal registered work was a book by John Barry in 1790 called the Philadelphia Spelling Book. And then this is also, it was interesting to me anyway, the Statue of Liberty actually was registered as a copyright in 1876. And the first motion picture was registered in 1894. And it's the Edison kinetoscopic record of a sneeze. So I found that to be interesting. So it's been around for a long time. Copyrights are an incredibly complex area with respect to intellectual property because of the nuances that are there. So, but let's talk a little bit about what happens. If a contractor assigns their copyright in scientific or technical publications under a government contract to a publisher, the government retains a paid-up non-exclusive license to reproduce and prepare derivative works. So this is something to keep in mind. But there's also another important aspect, which is that you can make copies of copywritten works, but please bear in mind that it isn't necessarily fair use if you are making multiple copies of it, or even a single copy, because copywritten materials used by the federal are not per se fair use under 17 USC 107. And again, this is a matter, if you're planning on reproducing something and assuming that it's free for the federal government to use, I would not take that position. I would certainly go to your legal office and ask. And again, I refer you back to the Sendi website and this particular publication. It's a rather detailed document that provides a lot of FAQs and information on copyrights. So a little bit about data rights. So the DFARS defines government and contractor rights in government contracts. And the DFARS also talks about what rights the government and the contractor has in data. But the one part that I think a lot of contract officers and folks confuse is that the government has the capability to own data. Its data is not copyrights. Copyrights are a compilation. The underlying data is something that the government absolutely has the capability of owning, and it is a proprietary interest. And I don't know, I was talking to you a little bit about trade secrets earlier. So in the real world, or in the outside government world, this would be considered a trade secret. In the federal government, we really do refer to data as data rights, and we have a compendium of rules, regulations, policies, and statutes on that. So contracts need to be clear on who owns the data and what rights are being conveyed and to whom. So I want researchers particularly to bear that in mind. So and what is most important, again, is that while copyrights state that the federal government cannot seek copyright protection, the underlying data is still proprietary interest and may be federally owned. So moving on, I wanted to talk a little bit about agreements, and I'll kind of go through this quickly, mostly because there is a part of this, particularly CRADAs, that you will be receiving additional information on. So there are many, many types of agreements, tech transfer agreements, and these actually fall outside of normal contractual law that governs majority of relationships and agreements in the federal government. So they're actually a separate statute, separate set of laws that apply, and they don't fall under FARs and DFARs in a regular course of business. So educational partnership agreements are actually agreements that are made to encourage the relationship between the federal government and educational institutions. And the idea is that they are to help promote and improve science, math, business law, tech transfer, or engineering education in these educational institutions. There's, of course, cooperative research and development agreements, and these allow the government to enter into collaborations with other organizations, whether they're federal agencies, industrial organizations. And the FARs and DFARs, again, aren't generally applicable to these types of agreements. With respect to CRADAs, we aren't allowed to provide funding outside. The federal government is not, but it is allowed to receive, excuse me, funding from or monies from third parties. We also have patent licensing agreements. Of course, this pertains to when there is a patent application or a issued patent. And these are, of course, statutorily provided for, and it allows the government laboratories to negotiate patent licensing agreement. That's really what the statute talks about. And there are three types of licensing agreements. One is a non-exclusive, where the government retains the right to license that particular patent or patent application, or even data to multiple parties. You have a partially exclusive license where the government limits the exclusivity to specific fields. And of course, you have exclusive licenses where the government licenses solely to one party or a named party, and the named parties in the agreement. And there are requirements for exclusive licenses, not so much that the federal government or the statute doesn't want to see exclusive licenses takes place, but they want to ensure that there's fairness in these negotiations. So when there is exclusive license opportunities, the federal government must publish their intent to grant an exclusive license in the Federal Register. So I mentioned briefly about royalties. So those are actually codified again for the federal government. So inventors will receive royalty payments from licensed patent applications or patents, or for the sale of patents. So I've provided for you several of the incentives that the federal government has for its inventors. And they are wonderful tools for promoting research and promoting innovation within the federal government and within the DoD and the DHA. So I'm going to end with this hypothetical that I want to share with you, and I would invite you to contact me and let me know your thoughts on this question. And I'll read this out to you. Dr. Rhoda Morgenstern is a researcher at the DHA MTF. She has developed a targeted therapy for leishmaniasis that appears promising. Dr. Morgenstern has not submitted her results for publication, but presented a poster of her work at a closed-door intra-agency meeting 2 weeks ago. Dr. Morgenstern received an email yesterday from a former government research collaborator, Dr. Mary Richards. Dr. Richards indicated that she heard of Dr. Morgenstern's progress from colleagues. Dr. Richards is now the director of the WJM Research Institute in Minneapolis, Minnesota, where they are carrying on similar research. Dr. Richard informed Dr. Morgenstern that WJM Research Institute receives some funds from international organizations with connections to foreign governments. Dr. Morgenstern would like to collaborate with Dr. Richards, share data, and submit any joint results to the top-tier Bloomfield Medical Journal for publication. How should Dr. Morgenstern proceed? Please send me your comments, questions for this hypothetical. I do have a solution set that I can provide to you if you're interested. And with that, I thank you again for your time, and I look forward to hearing and working with all of you in the future. Thank you.